Thank you, Madam Speaker. Madam Speaker, I come here as a freshman in this Congress. I come from northeastern Pennsylvania. My first time involved in the political theater, and I tell you, Madam Speaker, that I have plied my entire adult life in the civil courts. I have handled all manner of civil cases on behalf of defendants, on behalf of plaintiffs, on behalf of people, on behalf of companies. I've seen the whole spectrum of civil litigation, and I've been doing that both before and after the repeal of the mandatory LARA provision in 1993. So I am as qualified as anybody in this chamber to speak to the merits of this so-called lawsuit abuse reduction bill. It's a bill that should fail, and I say this not just because it tends to shut the door further on consumers seeking justice in the court system of the United States, but because it also reinstates a rule that has already been seen to be misapplied, to be misplaced, to be a bad rule. In 1993, we abandoned this rule for a reason. It wasn't because we pulled it out of thin air, the idea to abandon this mandatory sanctions under Rule 11 rule. It's because of the experience. The gentlelady from Texas held up the chart. You saw the spiking in Rule 11 filings. That wasn't because people were out diligently cleaning up the mess in civil courts. It's because they were encouraged to make those filings because of the mandatory nature of the rule. They felt like their clients expected them to file for Rule 11 if they won a motion or if they won a case, and it led to an enormous increases in unnecessary what we call satellite litigation. And it was the federal judges who complained at the judicial conference. It went to the Supreme Court. And Congress ultimately decided in its wisdom to abrogate that rule and abandoned it, because it was all of this wasteful litigation that was going on. We had a federal judge outside of Philadelphia, United States District Judge Robert Gothrop, who saw so much of that, he added a nickname to this Rule 11 litigation that people felt compelled to file. He called it zombie litigation. He called it zombie litigation, and he was enormously relieved when in 1993 this Congress did away with it. Current law allows judges to punish frivolous filings, and on occasion frivolous things happen in court, and the judges don't like them and they have the power to punish them, and it is with their discretion that they do that. We like discretion to be vested in federal judges. We're careful about selecting federal judges. We vet federal judges. We interview federal judges. We actually confirm them here on Capitol Hill to make sure that they have sound discretion and good sense. And it is best left to the sound discretion and good sense of federal judges to handle the situation when someone goes overboard with the filing. This is us here now trying to fix a problem that doesn't exist. The National Center for State Courts, make no mistake, tort cases constitute 5% of filings in civil court. It's debt collection. It's breach of contracts cases that take up 70%. From 1999 to 2008, tort case filings in state courts in the United States dropped 25%. Dropped to 2008. And this is all after the abrogation of the mandatory Rule 11 rule. So what this bill is really after is simply to make people afraid to go to court. What this bill is really after is to make people afraid to go to court to assert their rights, to assert their voting rights. I'm almost finished. To assert their voting rights, to assert their workplace safety rights, to assert the rights guaranteed them under the United States Constitution. This bill makes them afraid to go to court to assert their rights, and that's why I urge my fellow members, Madam Speaker, to vote against this bill.